Chair, you have a quorum.
All right. We're going to start with a couple of administrative matters. First, we've got House Bill 1257 on the docket, and that needs to be re-referred to the Committee on Local Government. Senator Norman moves, Senator Stanley seconds that motion. All in favor signify by saying aye. Aye. All opposed?
No.
1257. You can't vote twice. You got it. Next, we've got, and I'm going to, Delegate Bell is here. I'm going to wait just a second before we take that up. We've got House Bill 475, Delegate Foy's bill, excuse me, is that 175? 145, Delegate Foy's bill dealing with search warrants for tracking devices. It's identical to Senator Reeves' Bill 475, which passed out of this committee 15-0 and out of the Senate 40-0. There is a motion seconded to report that bill. Any discussion? Anybody in opposition to that bill? All in favor? Clerk will open the roll on the motion to report. Next, we'll take up 3 bills from Delegate Bell.
Mr. Chairman, members of the committee, good morning.
Which would you like to do first?
Mr. Chairman, I would like to do the House Bill 484.
All right.
And then we'll. Okay.
House Bill what?
484.
484?
Yes, sir.
Okay. And I would point out, members of the committee, that this is identical to Senate Bill 9, or it is the same subject matter as Senate Bill 994, Senator Howell's and my bill. All of these bills deal with restitution. We've got a substitute before us, which I think conforms this to the form of the Senate bill
yes,
as introduced, which is also governor's bill, by the way. Is there a motion to adopt the substitute? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed. Substitutes before us. Go right ahead.
Mr. Chairman, members of the committee, this comes out of the Crime Commission, and if you're really diligent, you'll remember last year we had a bill that was on the same topic, and it involves what do you do to collect restitution. The Crime Commission did a year-long study, discovered that the total amount of outstanding overdue restitution is $230 million, and we have a sort of a fragmented system of following up with it, keeping track of it, knowing who's paid and who hasn't paid. So this would set up a system whereby when someone was put on supervised probation before they were released, if there was still outstanding outstanding restitution, the PO would notify the court. The court would have a hearing. If there was no probation officer appointed, the court itself would set a court date for review, and then it would continue off these reviews for a period of time until the restitution was paid, or the court concluded that the gentleman was never going to pay, or 10 years had passed. The last year's bill was indefinite. This is not indefinite. It's got a 10-year window. Last year's contemplated indefinite supervised probation. This does not. This would contemplate it being the court. This was, as an aside, a part of a long negotiation with the governor that also involved the raising of the larceny threshold. And so, Mr. Chairman, members of the committee, that's the bill. I'm happy to answer questions.
All right. Thank you very much. Anybody? You want to ask Rob?
Yes, sir. I'm sorry, Senator.
I didn't miss it. If he's somebody that's just flat unable to pay it?
The court can release them from the ongoing visits. They still owe the money. It would eventually be docketed civilly, but there's no bring you back, bring you back, bring you back if you're disabled or in prison, or if you're just never going to pay.
Sure.
All right. Mr. Chair, question.
Senator Peterson.
And I know we had this previously, but let me just ask, would this in any way interfere with restoration of rights?
I'm not aware of any. I don't know.
No.
The governor's already been restoring people's rights if they were on unsupervised probation. And of course has the right to do it at any time for any reason.
Senator Edwards.
Has the prosecutors, common attorneys looked at this? Because it's somebody from the judges council because this is a complicated process. My experience has been common attorneys don't want to have anything to do with enforcing fines, restitution, or anything else. It's just too burdensome. They're too busy doing other things. And the question is, will this be done? Mr. Chairman, it might be helpful if council or someone could walk through the complexity of this bill.
Well,
happy to.
let's let the patron walk through.
right,
And
that'd be
I
fine.
would point out that this bill has been before us before. It has been through the Crime Commission. It was a Crime Commission recommendation last year. It was worked out at length with the governor's office. Secretary Moran is here, who can lend his voice to those who are in support of this bill. It is also a component of a agreement concerning the felony threshold. And so I'm sure that Delegate Bell is happy to walk through this. Before, I know Senator Norman has a question. I know we also have a number of patrons here, and I will tell you that we're more than happy to call you as your bill is about to come up. The order in which we have people signed up are Hope, Hurst, Collins, and Leftwich. And Rob will probably take a few minutes, it sounds like. So we're more than happy to call unless you are the next one or two. So, Senator Norman?
Mr. Chairman, I don't have a question. I mean, expediency, we've been over this bill thoroughly. It's been explained. It's now conformed, and I move to report.
All right, it's been moved and seconded to report the bill. I would like to give those in the audience an opportunity to stand up if they wish to speak in support of the bill. Come right ahead.
To speak?
Sure,
briefly?
we would.
Briefly?
I'd be delighted if they,
Mr. Chairman, members of
if
the
the
committee,
administration would
And
speak.
I'll try to limit my remarks to specifically the questions as well. And to Senator Edwards, I would say the Office of Executive Secretary reviewed this bill, was part of the process as we developed it, and in fact had some suggestions with respect to the language. It was in response to Senator Peterson's bill. That was one of the reasons Governor McAuliffe vetoed the bill last year, because it created something called indefinite probation, which suggested that you could never restore the rights. This bill addresses that. Just quickly, as the chairman said, this is a part of finally increasing the larceny threshold. But this bill in itself is a good restitution bill, and coupled with the larceny threshold makes it a very good bill, frankly. It does allow the judge, to address Senator Saslaw's point, to dismiss it if they cannot pay it. Only if it's an intentional refusal to pay would you be looking at a 19.2 violation, which is a contempt charge, not imposing violation of probation, which has other punitive ramifications. So again, just restitution, not fines and costs, just restitution. So I think this addresses all the concerns that Governor McAuliffe had last year with the veto, and is indeed supported by the administration. Thank you, Mr. Chairman.
Thank you, Mr. Secretary. Appreciate it. Yes, sir.
Thank you, Mr. Chair. Brian Porter, Commonwealth Attorney for the City of Alexandria, and on behalf of the Virginia Association of Commonwealth Attorneys, we do support the bill.
All right. Well, thank you very
Thank
much.
you.
Anybody wish to speak in opposition to the bill?
Good morning, Bill Fair, ACLU of Virginia. We strongly oppose the bill. We just don't think we should be keeping people on criminal probation longer than others based on their inability to pay.
Okay. Thank you very much. The motion before the committee.
I did have one question, Mr.
All right.
Chairman.
Yes, sir.
And it's a question raised by Senator Edwards. The bill does require that before an individual is released from supervision, each time an individual is released from supervision, that the attorney for the Commonwealth must notify the victim. And Senator Edwards had asked whether the Commonwealth attorneys had any objection or issue with this additional burden. I don't see any representative, but I wanted to make sure that that issue was raised or the question asked.
Well, I think the representative was just up there. Maybe he'll come back.
Thank you,
Yes,
Mr.
sir.
Chair. With regards to notification of the victims, I'm not sure whether or not the bill requires a specific notice to the victim, but I do know that in general, my office, the Commonwealth Attorney's Office, always would notify the victims for any hearings with regards to restitution.
Okay.
Thank you.
Mr. Chairman, what the bill does is require that before an individual comes off of supervision, that the attorney for the Commonwealth notify the victim that the individual is coming off of supervision. And that does seem like a remarkable additional burden for the Commonwealth attorneys, but I have no objection to it. I just wanted to make sure the point was raised.
Mr. Chair, my understanding from talking to the patron is that it does say if practicable. So in situations in which the victim cannot be located or we've lost contact with them, it would not be an absolute requirement. Generally speaking, it would be something that would be accomplished through victim witness advocates who are in contact with the victims on a general basis. Thank you.
All right, thank you. Is that it, Steve? All right, the motion is to
Mr. Chairman,
report the substitute.
Speaking to the
Yes, sir.
substitute,
Senator Edwards.
I appreciate all the hard work, and this is probably the best we're going to get, but this is going to be, for lack of a better word, a semi-nightmare for a lot of prosecutors and defendants, and it's going to be a lot more complicated since I know a little bit about the system than people realize. And I'm going to vote no because of the fact that I think we could do actually better.
All
Mr.
right.
Chairman,
Senator Howe.
I would just like to go back to what generated all of this in the first place, and it was the Crime Commission discovery that there were $270 million due to crime victims, and the system that we have is absolutely not working. A lot of effort went into this, and I am very hopeful that as a result, the victims of crime, the victims, will get what the courts have already adjudicated they are due. Thank you, Mr. President.
Anything further? Clerk will open the roll. All right.
Ayes 14, does 1.
That reports. We also have Senate Bill 994, which is identical. Is there a motion to take action on that bill? It's been moved and seconded that Senate Bill 994 report. Clerk will open the roll.
Ayes 14, does 1.
All right. Dolly Bell, 483.
Yes, sir. Mr. Chairman, members of the body. So this is a simpler bill, but it's in the same wheelhouse. As we were exploring problems with restitution, I'm embarrassed to say that a reporter found something we hadn't found. Carrie O'Brien from WRIC discovered that while we were looking at how you collected the money, no one was keeping very good track of how the money, once collected, got delivered to the crime victims. And it turns out, again, we have a fragmented system where no one's keeping track, and it just sits in various clerks' offices and in the Crime Injury Compensation Fund going undelivered. And it's $8 million. $8 million is sitting there. We raise about $400,000 every year that doesn't, defendants doing the right thing, courts doing the right thing, everybody does the right thing, but it just doesn't get to the victim at the end of the process. Mr. Chair, the clerks, when they saw the bill go through the House, spotted some language that'll make their jobs harder, not easier, that they have given to staff. It's a technical, by my lights, it's technical. I would certainly have no objection if the committee chose to take it up. It's how they word the redaction.
Kristen, you want to report that amendment?
Mr. Chairman, there are two amendments. On line 77, delete "the clerk shall redact." And also on line 77, after information, delete "from the form before disclosing a copy of the form to any person," and insert "shall be confidential, and the clerk shall not disclose such confidential information to any person." So that sentence would read, "Except as provided in this section or otherwise required by law, the victim's contact information shall be confidential, and the clerk shall not disclose any such confidential information to any person."
All right, any discussion on that amendment? Is there a motion to adopt the amendment? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed, that amendment's adopted.
Mr. Chairman, aside from that, you had a identical version of this bill go through the Senate, and we will be making that same change with your permission in the House, and then they'll be identical and they can.
My understanding is that we're not going to conform this. We're going to leave the bill in the form that it left the House, unless there's any objection. Language was taken out in the Senate because of a funding consideration that I think is potentially going to help make this better, but I think your bill needs to be re-referred to Finance Committee.
Guy's name.
Right. So the bill as amended is before us.
Move to report and refer to finance.
All right, it's been moved and seconded. All, clerk will open the roll.
Ayes 15, no zero.
I'm sorry, I didn't give anybody in the audience. We'll unwind it if anybody wants to speak in opposition to that bill. All right. Your next bill is House Bill 481.
Yes, Mr. Chairman, members of the committee, this is a little bill in comparison to the other two, which were long studies. Knocked on somebody's door this summer. He said, my son's away in college, got jury service notice, and would like to put it off till he's home for the summer. And I wasn't even aware of this, but there's an occupational inconvenience that allows for deferral, not for being released from jury service, but lets you put it down the road a little bit. And this would add someone who is enrolled as a full-time student at a higher education institution to be considered for this as an option. So,
as a legislator who has 3 colleges and universities in my hometown, I see a lot of merit to this proposal. Anybody have any questions of the patron? Anybody in the audience wish to speak in favor of or in opposition to the bill? Senator
Mr. Chairman,
McDougal.
I don't have a specific opposition to this, but I just caution, there are a lot of people who have a lot of issues of attending jury service because it can be inconvenient with work schedules or family schedules, and I would hope that this does not start a flood of this type of legislation going forward in the future.
Maybe in the future, we need to repeal an exemption for every exemption we had. So, you have one you want to take away, Rob?
I didn't know this existed, in all honesty. This allows for deferral. When we do jury cases, routinely people say, I just can't. And if the judge says, well, would next time be better? And they go, no, then we all kind of just suck it up and do it.
All right.
This would say, you got to wait till the summer or the Christmas term or something. I didn't know this. I've never seen this before.
Anybody in the audience wish to speak in favor of or in opposition to this bill? All right. It's been moved and seconded to report the bill. Clerk will open the roll.
I thank the chairman. I thank the members of the committee. Thank you.
Thank you. Next, I guess we've got Delegate Hope.
Mr. Chairman,
Senator Howe.
before Delegate Hope starts, I just want to say I had the identical bill that I asked to be carried over. I think at that point we had insufficient information about the types of field testing that he's talking about. So I hope we'll give him an opportunity to explain that and not just deal with his bill like mine.
And I did deliberately not take that up in the preliminary matters because you withdrew your bill rather than presented it. So I don't know that the committee has really taken a position on it. So we'll certainly give Delegate Hope a hearing, and we may address some of the complicating factors. Delegate,
Great,
go
that's
right
House
ahead.
Bill 88. I have 2 before you. House Bill 88 is one of them, and we'll start with that one. And thank you, Senator Howe, for that, Mr. Chairman, members of the committee. House Bill 88 allows the Commonwealth to rely on field tests results in trials involving misdemeanor charges of possession with intent to distribute marijuana. The change creates the same testing procedure for all misdemeanor marijuana cases. We currently allow this for misdemeanor. This just expands this to misdemeanor possession with intent to distribute. Of course, anyone impacted by this change would still be allowed to have a laboratory test upon request. And so I do have experts here from the Department of Forensic Science that can talk to the accuracy of these tests.
Okay.
I have one of my Commonwealth attorneys, Assistant Commonwealth Attorney from Arlington, came up to talk about his expertise and what he's seen with these matters. So I know there's some questions about this. I think they can address those.
We may also want to question the Commonwealth's attorney from Arlington about the strip search legislation that was introduced earlier this session as well.
That's a really good bill. But well, that was brought by the sheriff.
Glad to
he
hear
probably
you say
wouldn't have
so.
any- He wouldn't have any.
All right, let's start with any questions of the patron.
Mr. Chair,
This is not
Senator
going well.
Deeds.
you know, you said they could ask for expert if they wanted to. This is a field test. It's not coming from the Division of Forensic Science. when are they put on notice that they have the right to object and ask for a field test, ask for an expert?
I mean, we can ask the Commonwealth's attorney when that process does occur. I mean, we can have them come up.
And they can come up, but my understanding is there's no specification as to when it occurs.
Mr. Chairman.
There
Mr.
is no
Chairman.
specification. When you've got a certificate from the Division of Forensic Science, the Commonwealth's attorney sends a notice, the defense attorney then has a chance to object. When you have a field test, you see it in court.
Mr. Chairman.
All right, let's
Okay.
let somebody answer the question before, and if you would, it's not testimony, I want you to answer the question, if you don't mind.
I'm David Ledbetter, Commonwealth's attorney of Waynesboro. I'm here on behalf of the Virginia Association of Commonwealth's Attorneys to answer that specific question. When a person is issued the summons or arrested on the misdemeanor charge, they are provided a notice where they can submit for the demand to have the substance sent off to the Division of Forensic Science for analysis. So they're provided notice at that time. Likewise, if they retain counsel, counsel at that time can also similarly make that demand that be done. It can be any time up to the trial of it. So they are notified.
Mr.
Senator
Chair.
Deeds.
But when they're initially given their notice, they don't have counsel and they can waive that right without the advice of counsel.
Mr. Chairman, if I may, it's not really a waiver of a right. It's just simply not executing the demand for the notice. So it's not like they give them the options. Here, you want this tested? Yes, no. It's at any time up to trial, they can ask for that substance to be sent off and ask for it to be tested. Likewise, if they're appointed counsel or the retained counsel, that counsel can also request for that to be done. So it's not a waiver at the time of arrest. They have that right anytime up to trial.
Senator Stanley.
Mr. Chairman, I mean, my concern, he's exactly right about that, but, you know, we have these bags and the trunks are secured by the police officer. Would temperature change, it has been shown scientifically that a change in temperature such as extreme heat or extreme cold can affect those tests, isn't that correct?
Mr. Chairman, I'm going to have to call on somebody from Division of Forensic Science for that. That's beyond my expertise as a Commonwealth attorney.
Good morning, I'm Linda Jackson. I'm the director of the Department of Forensic Science, and my background is in drug chemistry. Back in 2006, when this legislation originally went through for the simple possession of marijuana, we did extensive testing on the Duquesnoy-Levine field test kits, which are the only ones that are approved for this purpose. There are other field test kits that are available for marijuana that are not approved, the regular Duquesnoy test and the KN test. They both are not as specific as the Duquesnoy-Levine test and didn't meet our needs for this purpose. I did happen to take one of the Searchy kits that we have purchased on the contract for the state, where we provide them to law enforcement, and I had it in an envelope in my glove box, and I had it in there for 2 years. I forgot about it, truthfully, because it was in a car that I didn't usually drive, and I took it out.
Sure you did.
Sure I did. I didn't have the marijuana in my car, just the field test. Yes, sir. So, but I did take it out and was happy to see that it had the same result as when we had initially tested them.
Mr. Chair.
Senator Stanley.
Can you speak to what kind of training each police officer or deputy sheriff goes through in terms of making sure that they're well-versed on how to do this and that the tests are reliable?
I actually cannot testify to how they do the training. We do not provide training to the officers. When we are doing our approval of the kits, we are approving that when you follow the directions that the manufacturer gives you and you have a substance that is of a normal street concentration, if you follow the directions, you will get the answer that they said that you will get. And so that's kind of the testing that we're doing, but we do not provide training, and I don't know that any is officially required.
Mr. Chairman.
Senator Stanley.
Understanding that the corporation that makes this test kit is confident, and if you follow the instructions, you will get the result that you desire. What is the reliability on those kits? Do you know?
So, there are no studies done that say, where ones that were field test kit are then submitted to the lab and we do a parallel study. There's not a published study for that. The Duquesnoy-Levine reagent that is in this particular kit is the same one that we use as one of our 3 tests in our analytical scheme for marijuana in the lab. It's just packaged in those little kits. So we don't use it in the kit. We use it, just out of bottles that we make. So the reagent itself is, there are a lot of papers that talk about different plants being tested with that reagent, and there are papers that say that there are no other plants with the same plant morphological characteristics that give a positive result. There are a couple of plants that are sometimes published saying that they do give a similar result, and back in 2006, both of those plants, which is the it's a nutmeg and a mace plant. We purchased both of those plants and we did the testing, and the results were, I would say, inconclusive. And we do suggest that any officer who receives an inconclusive result automatically sends those to us for testing.
Mr. Chairman, last question. So if my grandma's got nutmeg in a bag and gets pulled over by a police officer and he thinks it's marijuana and gets a false test, she's going to have to get a lawyer? Is that what you're saying?
No, the nutmeg itself, like out of a spice rack, did not do it. It was the plant itself.
So, Mr. Chairman.
Sarah McDougal.
So my mother's nursery, then, when all her plants get tested, that's when we're going to hit it. Mr. Chairman, some of us who practice in this regularly do not have a comfort level with having a less scientific test that would have somebody move on to a trial in front of a jury potentially, and I would move to PBI.
All right. It's been moved and seconded. Before we take a vote on that, let's do hear briefly from the Arlington Commonwealth's attorney who came down to testify on it.
Thank you. I'm Andy Parker. I'm the Chief Deputy Commonwealth's attorney.
You going to talk about the strip search too?
From Arlington. I'm not going to talk about that. I don't know anything. That's a sheriff's office issue.
Oh, okay.
The one thing that I've been doing this for 25 years, and I've never seen a case where this field test, and I'm not saying it hasn't ever happened, but I've never seen a case in my experience where this field test tested positive on the street, the Duquesnoy-Levine reagent test, and then the lab result came back negative for marijuana. I spoke with the head of the controlled substance section at the central lab of DFS. He's been doing this since 2002, and he had the similar experience. This field test is very reliable, and as you heard, it's one of the ones that they use at the lab. One thing that, two things I think are important to note. One is we've already doing this procedure for simple possession of marijuana. This is only, which is a misdemeanor. Second offense is a Class 1 misdemeanor. We're only talking about Class 1 misdemeanors here, same substance, same classification.
But
So-
Mr. Chair,
Senator Deeds.
with simple possession, under bills we're passing this session, you can expunge those charges, right? You can't expunge possession with intent to distribute, even a misdemeanor.
Well, as it stands now, the way the law is now, you can't expunge regular marijuana possession either. So, I mean, what I'm saying is it's the procedure that's been in effect since 2006. So. One other point that I think needs to be made is that the Department of Forensic Science has limited resources. This kind of came to our attention in Arlington because there's an extraordinarily long waiting period to get a lot of the powder drugs, the heroin, the opioids tested. And that's due for a number of reasons, the increase in volume of those drugs and the new procedures they're doing to protect their own personnel. But this kind of thing doesn't eliminate testing for marijuana. It just doesn't make it mandatory in every case. It would have the effect of shortening the wait time for testing of these other more serious felony drugs. So that's something I think that you all should consider as well. I don't know if anybody else has any questions.
Any other questions? All right, there's a motion to pass the bill by indefinitely. If you want to come up and speak, you can. All right. Any further discussion? Clerk will open the roll. Thank you.
Ayes 12, noes 3.
You did well.
I tried.
That's three more votes than it got the first time.
All right, I have one more bill. This is a little bit easier. House Bill 52. What I want to do is I want to ask Mike Doucet from Association of Commonwealth Attorneys to come up. He has an amendment. This did pass out unanimously in the House, but they had some concerns that they brought to me, and so what I want to do is have him offer the amendment, and we'll put it in the proper posture, and then I will explain real quickly.
All right, Mr. Doucette.
What's happening.
Step right up.
Mr. Chairman, Mike Dusek, Executive Director of the Virginia Association of Commonwealth Attorneys. We had some concern with some of the language, specifically on line 26 and on line 85. And our concern is there are occasions when an inpatient evaluation is suspected to be needed, such as if there's some issue of malingering, a possible issue of malingering. There are some medical conditions that would need an inpatient evaluation, such as cirrhosis, such as kidney disease, such as a recent brain injury. And this is not something that I've come up with. This is something that Evan Nelson, who is a forensic psychologist, well respected around the state, has suggested, and we have asked Delegate Hope if he would add on line 26 and on line 85, after the word jail, unless an outpatient evaluation has been conducted and the outpatient evaluator opines that a hospital-based evaluation is needed to reliably reach an opinion.
All right. Is there a motion to adopt that amendment? Anybody? All right, it's been moved and seconded to adopt that amendment. Any discussion of that? All in favor signify by saying aye. All opposed? All right. Thank you. Now, tell us real briefly with this what the bill does. I think this bill is probably in good shape.
So for the competency issues for someone to stand trial, the preference in the code says that should be done, the evaluation should be done on an outpatient basis. But what we're seeing increasingly is that people are coming in inpatient. And so that's what the bill does, is just clarifies that we want to make it more instances of where it's outpatient. This helps prevent unnecessary hospitalization.
All right. Anybody in the audience wish to speak for or against this bill? Bill is before us. Wow. It's been moved and seconded that the bill be reported. Clerk will open the roll.
Thank you, Mr. Chairman.
All right. One for two. All right. Next, Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. Before you is House Bill 634. This is a bill that is very similar to a Senate bill that Senator Chafin introduced last year and was passed, that permitted staff of the Department of Forensic Science and Division of Consolidated Laboratory Services to testify via two-way communication in preliminary and sentencing hearings.
They liked the bill so much that they wanted somebody to bring them into it this year?
Well, it would make a significant impact in their ability to save staff time and resources too, so there would be some cost savings associated for the Office of the Chief Medical Examiner. But Mr. Chairman, yes, there is, as you know, in some parts of Virginia, a long travel time for members of the Office of the Chief Medical Examiner to travel in order to appear in court. This would not apply to the trial itself, again, limited only to prelim and to the sentencing phases, but this is something that OCME staff would estimate would save about 23 days of staff time per year, and Dr. William Gormley from the office is also here to answer any questions that the committee may have.
And, you know, this is one of these bills where, you know, we start something and the ball starts rolling faster and faster downhill. And for those of us who are practicing lawyers, I mean, it does give some concern about the diminished use of live testimony in court proceedings. And make no mistake, we're going to see others next year that are looking to you know, save time and save resources. And my concern is that, you know, saving time and resources is good, but it undermines the rights of an accused. It may not be a lot, but it does.
Mr. Chairman, having gone from a profession where you're using television to then having to go appear in before person, I can certainly appreciate the value of having to appear in person. But you know, we have
Good to see you.
It's good to see you too. We have made some very, very narrow exemptions for what you're talking about, and obviously the testimony from children and other certain cases. I think that, you know, if we start looking at maybe a slippery slope, I think we just look at it on a bill-by-bill, a case-by-case basis. And I
We
think
call it a Christmas tree.
Yes, sir, Mr. Chairman. But I do believe that this is a very specific, thing to address for the office, and would be something that would just involve what are normally fairly routine hearings. In those
And I think we understand. Let's take questions for the patron.
Mr. Chairman.
Senator Stanley.
Delegate Hurst, it does not say anywhere where I can see this, but, you know, when you have these kind of video communications, let's say in a preliminary hearing of a medical examiner, it would be a benefit to the defense to have that exchange of direct and cross-examination recorded, but I see nothing here. Am I missing something, that this could be not only a video appearance, but also a recording that would be made available to the defense?
All I'm seeing after double little I is shall be identified on the video, but not necessarily kept and maintained for any potential future use. But and I would also defer to Dr. Gormley and to the committee about any potential changes to try and address any of that concern. I certainly understand what you're asking and what the issue is.
And Mr. Chairman.
Senator Stanley.
For an indigent client who might not be able to afford a court reporter in such a preliminary hearing, that could be very important for them. And merely just not a tape recorder that the defense lawyer sometimes brings. So that would be a concern, or at least I think a better way to look at this, that this, not only that you have the ability to see what you're referring to, the materials that were read or used by the witness during the testimony that are identified, but also a preservation of that testimony for further use in criminal cases. And Mr. Chairman, I've never seen an ME ever come to a sentencing be on the defendant's side in all those times that I've had that. So I just think that if that was going to make the bill better, that would be the way to do it.
All right, let's hear from any other questions of the patron.
Yeah, Mr. Chairman, if it's done by video, it wouldn't be hard to, record it. I assume that could be done very easily.
Isn't that so?
I think that, jurisdiction to jurisdiction, it can vary, but that we certainly do have video recording processes available in courtrooms.
All right, let's hear real briefly from those who wish to speak in favor of this bill. Yes, sir.
Mr. Chairman, members of the committee, I'm Bill Gormley. I'm a chief medical examiner, and the administration is in favor of this bill. One thing about this bill is it actually requires nothing. It just enables. So there's no requirement for the use of teletestimony for preliminary or sentencing or other minor hearings in a case. It says it can be used if everybody agrees to using it. Also, the bill makes it very similar to that of the same situation as with DFS and DCLS, which are in the same position as we are in statewide laboratories.
Who's that? Senator Dees.
Mr. Chair, it doesn't look to me like it requires all the parties to agree. And if this bill might be better if it did require, upon showing of good cause, or some sort of hearing by the judge, the court beforehand.
Mr. Chairman.
Senator McDougall, then Senator. I'm sorry.
Mr. Chairman,
are you finished,
I'm
Senator
finished.
Dees?
I just want to make a point.
Senator McDougall.
I agree with Senator Deeds. There's no requirement that it requires anybody to agree, and it doesn't appear to me that there's any way to object to it. I mean, it just says any testimony offered by the hearing, so if the judge determines it, it's just there. My concern is, at the preliminary hearing, these are cases where somebody's been killed. It's a homicide. So these are not minor cases, and if somebody's convicted, they will potentially go to the penitentiary or be executed. And I do not know why we would not want to require a key, maybe the key witness in that case, to be present at the preliminary hearing. That escapes me.
Mr. Chair.
Senator Stewart, then Senator Peterson.
Thank you, Mr. Chairman. Can you all tell me why you need this ability?
Well, it saves us from going to court multiple times for the same case.
Mr. Chairman,
Senator Stewart.
are y'all unable to go to court, testify?
We're able to go to court, but when we're out at court, we're not in the office doing the work what we're supposed to be doing.
Mr. Chairman,
Senator Stewart.
is your caseload such that that's presenting a problem to you?
Yes, sir.
In what, how is it setting cases back? To what extent? Explain that to me.
Well, in particular, our caseload and our accreditation is determined by the number of cases that everybody, that each physician is able to do. This year, we have a budget amendment in to markedly increase our staff simply to keep up with the number of cases that we need to do for mostly drug overdoses. It's about 1,000 more cases a day or a year. So we are having diminished resources, so the more time our physicians are out testifying in trials, and particularly in the western districts where there's a substantial distance, can take up to a full day to go testify at an individual trial.
All right, Senator Peterson.
Yes, sir. I had the same question they did. For example, what would happen if you were to issue a subpoena for this witness? But I think the answer is, if I could move or suggest this amendment, where it says on line 25, may be presented, and interlineate the words by consent of all parties. And I think I understand that if it's a pro forma hearing, you don't necessarily need the medical examiner to drive out to, Buckhannon or wherever. But I do agree that if you're the defendant, you may want to cross-examine him live, and you wouldn't consent to that. So I would just move the words by consent of all parties after may be presented. And I'll make that motion.
Second.
All right, motion properly seconded to amend. All in favor signify by saying aye.
Aye.
All opposed?
Mr. Chairman,
Right,
I have
Senator
another
Edwards.
potential amendment to say such testimony should be recorded, which shouldn't be hard. You got the video already. I don't know where you put it at the end.
Is that going to generate a fiscal impact? Well, we'll make that amendment and send it to finance.
Nothing should ever go to finance.
All right, so there's no motion to amend.
Well, the Supreme Court is here. Could the Supreme Court?
The Supreme Court, I don't think has any intention of saying anything unless you've got that amendment up there.
Well, I'll make the amendment. I'd like to hear what the Supreme Court says.
Substitute
Well,
motion.
I'd still like to hear what the Supreme Court has to say about it.
All right, I'm sorry, was there a motion or report?
I'll move the report. As amended, second.
Mr. Chairman,
Senator Stewart.
I'd like to make a substitute motion. I concur with Senator McDougal that this is very concerning to me, and I know that we did this, I think, for some of us reluctantly with DFS, but in these cases, we're looking at a murder. And it concerns me a great deal that this testimony could be considered by two-way video, so I would move that the bill be PBI.
Mr. Chair.
It's been moved and seconded to pass the bill by indefinitely.
Mr.
Senator
Chair.
Peterson.
I'd make a substitute motion to report. I think we've.
Well, that's the
Oh, that was,
primary
all right.
motion. This is the substitute motion is pass it by indefinitely. If that fails, we'll go back to the primary motion. All right, clerk will open the roll.
Ayes 8, noes 7.
All right, the bill is passed by indefinitely. Interesting issue and tough one, so I appreciate your presentation.
Thank you, Mr. Chairman.
I'm sorry, who's asking? All right, next, Delegate Collins. All right, Which bill do you want?
We can take up 292. I think that's the easier of the two.
Okay, 292.
Thank you, Mr. Chairman. Ladies and gentlemen, senators, this is adding abduction to the list of things that are reported to a school administration when one of their students commits a crime outside the school grounds. We had an incident where a student abducted another student, but it was not on the school grounds. And then the next morning, the two students were in school together, and the school administration had no knowledge of the prior act that had occurred. This does not, the school, if you look at the code section, it's a fairly lengthy code section, but the school is required to take no action. It's just a simple matter of once an individual is taken through a juvenile is taken through the process, through the intake process, that the school is notified for certain criminal acts. And this adds abduction to that list of criminal acts.
So Chris, your example, so what happened was a student abducted another student, was arrested, processed, and then both students were back in school the next day.
Yes, sir.
Okay.
And we're talking about juveniles. If he was 18 and if he was 18, this would not have been an issue. But since they were both under the age of 18, the juvenile intake was unable to notify the school administration of the incident.
And I see no issue with this except, and just want to point out that this is a growing section. Steve or Charles?
I fought the Christmas tree.
How many offenses, can you give the committee an idea as to the offenses that are already on that tree? And your argument and your example is a good one.
Many.
Mm-hmm.
A lot.
Firearms, homicide, felonious assault, bodily wounding, criminal sexual assault, distribution of controlled substances, arson, burglary, robbery, street gang, mob violence.
Right.
Mr. Chairman.
All right.
Yes, just a
Sarah
question
Peak.
To the patron. If they're charged with abduction, how did both of them end up in school the next day?
Because through excuse me, Mr. Chairman, Senator Peak, through the intake process, they did not detain him after they released him to his parents that evening.
Indicating, Mr. Chairman.
Senator Peak.
Probably was not a very serious concern of abduction if they let the juvenile out to attend school the very next morning.
He was charged with abduction. My understanding is that the case is still pending, but it sounds as though there's a plea agreement. If you're of good behavior, things are reduced and things of that nature in juvenile court.
Mr. Chairman, was this a boyfriend-girlfriend situation at that local school?
It was not, but they were familiar with each other from school.
Okay.
All right. All right, anybody in the audience wish to speak in favor of or in opposition to this bill? All right, the bill's before us. Is there a motion? Move to report, somebody? It's been moved and seconded that the bill be reported. Clerk will open the roll. All right, your next bill.
This is House Bill 280.
Hang on.
I'm sorry.
Yeah.
Almost.
Vote my proxy. All right, your next bill?
House Bill 289. This actually is not anything new. This is just we did not add any new words to the code. We created these separate paragraphs, lettered paragraphs. This is similar to a bill I brought last year where we were trying to address an issue where judges were remanding and referring cases from circuit court down to juvenile court. At which point individuals who maybe came back 6 months later on a child custody case because there's a perceived change in circumstance would then have to start in juvenile court just to go back up to circuit court where the judge just already heard the evidence 6 months prior. Crawford v. Crawford already establishes that they have concurrent jurisdiction, and this is the code section that we had in place. So we have added no new language, no new law. What we did was rearrange it a little bit to try to comport with the Crawford v. Crawford standard, where an individual, it's not an automatic, where it automatically gets remanded down to juvenile court, but juvenile court and circuit court still have concurrent jurisdiction, and any party can request the matter to be referred back down to juvenile, juvenile court for further proceedings. but that the court would maintain jurisdiction until that's done.
All right. Everybody got that?
Mr. Chairman, in other words.
Senator Edwards.
One or both of the parties would have to ask for it to be transferred back to the juvenile court. Otherwise, it's remain in the circuit court. Is that right?
That's the current law, yes, sir. That's the current ruling under Crawford v. Crawford.
No, I think the current ruling is the judge can do it even if the parties don't ask for it.
They have been doing
I know
it.
I know
Okay,
it.
certain judges have been doing it. Other judges have not been doing it. This brings a consistency throughout the Commonwealth.
All right, I think the Family Law Coalition may have something to say about this.
Thank you, Mr. Chairman, members of the committee. We appreciate Delegate Collins bringing this before the committee. There were inconsistent rulings across the state as to what the procedure should be under the Crabtree case and also under the current statute. So we felt that it was necessary to clarify the circumstances under which the court could remand, and they can remand if there's a motion by either party. And we also found that certain courts were requiring a final decree to have language remanding, even if the parties objected. And so there was kind of an opt-in versus an opt-out versus an opt-in.
So this is a Family Law Coalition?
It is.
Bill?
It is.
Okay.
And we appreciate, again, Delegate Collins bringing that.
All right, any questions? Anybody else in the audience wish to speak to this bill? Senator Stewart.
Mr. Chairman, just so I understand, this then precludes a circuit court judge from sending it back to juvenile court on the court's own motion.
Right.
It does. And if you look at the statute, it currently requires the motion of either party. Under line 32, it already requires a motion of either party to send it to juvenile court for modification. It doesn't require it for enforcement.
Modification only.
Okay, bill is before us. It's been moved and seconded the bill be reported. Clerk will open the roll.
There's a motion.
Technology is great when it works.
All right, all in favor signify by saying aye.
Aye.
All opposed? All right, the bill reports.
Thank you, Mr. Chairman.
Should we raise your hands?
Too bad. All right, Delegate Lefkowitz.
All right, thank you, Mr. Chairman. This is House Bill 745, and it would reduce adultery from a Class 1 misdemeanor to a civil offense. And so I guess I would start out by asking the obvious question, why do we want to make...
I'm sorry, you're on which bill?
745.
745.
I think it's the only one I have today.
Yeah, this is another bill that has been considered by this committee. We just wanted to give you another crack at it. It failed to report, but figured that you wanted to give it a try.
Yes, sir. So I guess I'd start off by saying, why do we want to make conduct that's not appropriate, reduce the classification of offense? And my response to that would be that, I've spent almost 30 years doing domestic family law and divorce matters, and the statute of limitations for a misdemeanor is 1 year. So what happens many times is someone will file for divorce based upon the inappropriate conduct of their spouse. And then the matter sits for a year or longer before they actually start litigating the case, because the Fifth Amendment prevents the spouse that is the innocent spouse from engaging in discovery, not only as to the conduct of the offending spouse, but any of the documents or information is necessary to settle the monetary or property issues involved in the divorce. So, for example, husband or wife has a indiscretion, the other spouse finds out, they file for divorce, and even if they're interested in pursuing, having them labeled an adulterer, they ask for financial records that would help settle debt, property records and things like that. The other spouse who has engaged in the indiscretion can refuse to respond to anything that may even lead to evidence that could find them guilty of a misdemeanor. And so the matter just lingers and creates all kinds of delays and expense. And so then after the 1 year passes of the offensive conduct, the statute of limitations has passed, and now they can find out anything they wanted to find out, including asking their spouse in a deposition, did you have an affair with Jane Doe or John Doe? And they're required to answer that. So the fact that it's classified as a misdemeanor doesn't prevent all this from hitting the sunlight. It only delays it by a period of 1 year and slows down the entire litigation process. And I believe that, there's some unlikely allies in this, and that we find that adultery is something that no one would say is okay, but we know it happens. But based on the reasons that I think I've explained, the Family Law Coalition is in support of the bill, and as is the Family Foundation. So
Okay.
I know you've heard this before, and that's.
We have. Those who wish to speak in support? Yes, ma'am.
Mr. Chairman, Cheshire Eveley with the Family Law Coalition. Just briefly, because I know you've heard this before, but there are 3 areas the court should consider adultery for the grounds for divorce, for equitable distribution, and under current law for a bar to spouse support. So under the current law, because there is a clear and convincing evidence requirement to prove adultery, you may have an adulterous spouse who has committed a long-term affair and is still going to get spouse support because you can't prove it by clear and convincing evidence. This would lower the standard to preponderance and allow the court to consider it in those 3 areas and may prevent an injustice.
Okay. Any questions? Anybody in opposition to this? Is there a motion? No, it simply removes it as a misdemeanor. For the divorce case. Right. Anybody have any questions? All right, bill's before us. Come on now. Anybody can make a motion or report? There are a handful who actually voted for it last time, including me. Anybody want to make a motion to pass the bill by? We've got to do something with it.
I'll move the PBI.
All right. Is there a second?
Second.
All right, it's been moved and seconded to pass the bill by indefinitely. Clerk will open the roll.
Appreciate the committee's time. Thank you.
Whoops. All right.
Ayes 11, noes 4.
Thank you. Next, we've got Delegate Habib.
Y'all are cold, man. That was brutal.
Next.
I don't know if I want to go next.
Best for last.
Yeah, I mean, this bill, 1336.
1336.
Was not intended to be controversial, wasn't controversial, apparently is now. So let me tell you what it does. And I mean, y'all are all lawyers. Y'all know what the law is and ought to be. So there was a recent Supreme Court case came out right before session that, and again, it's based on a set of facts. The problem is the result of that was Virginia Supreme Court said you have to prove bad faith in order to get a spoliation instruction in Virginia. Well, when the evidence of bad faith is always in the hands of the spoliator, that becomes a burden that's almost impossible to meet. And frankly, notwithstanding what I'm sure you will hear from some other people testify here shortly, I think most of us thought that case was just not reflective of Virginia law. Spoliation applies to all parties. Actually, the only times I've ever gotten a spoliation instruction were in commercial cases. Plaintiffs can get them, defendants can get them. Personal injury claims, in a products liability case, it usually works against the plaintiff. So they really should be sort of agnostic, and it really is just a jury instruction question. So we actually drew the bill as narrowly as it could be drawn. So let me just point a couple of the things in the language to show where we went sort of very, very narrowly. It only applies if the alleged spoliator knew or should have known that the material was relevant. It only applies if it was destroyed or lost or spoliated at their direction, with their consent, or with their knowledge. So it doesn't apply to accidental spoliation. And then only if you prove all of that, then the court may give a jury instruction that says the jury may infer. So there's no presumptions, there's no mandatory instructions. Frankly, the bill I would prefer to put in would say if you spoliated it, you have to give a presumption of a finding. But we didn't do that. We took the inference route.
Now, let me ask you this, I've heard a lot, and I've spoken to a lot of folks over the past week about this. And what I've heard is that opponents of your bill are big fans of Rule 37 of the Federal Rules of Civil Procedure. They like that better and seemingly would like to codify that. Have you heard that?
I have not. For some reason, the opponents haven't been real specific with me about their complaints about this bill. But there's a lot of ways to get at this issue. The fundamental question is...
Well, Rule 37 takes a much different
approach.
As a matter of fact, it creates a presumption.
Yeah, if people want to create a presumption, I'm totally cool with presumption.
Okay.
I'm shocked. Frankly, that strikes me as sort of an argument to be against a bill without really understanding what you're arguing for. If you want to create a presumption, let's do it.
Well, let me ask you this. You know, and there are actually some non-lawyers on this committee. And there's some folks who may not litigate as much as others. But tell us what's the difference between an inference and a presumption?
Yeah. So, I mean, if you have a presumption, then that meets a burden and has to be rebutted. An inference simply allows the jury to essentially infer that the facts exist.
Is that like circumstantial evidence?
Yeah.
A jury can infer something from circumstances?
Right. That's right.
And I looked at this case, and I really, until I sat down and spent a little time with the law and looked at this Emerald Point case that I think this deals with, you know, I really didn't have strong feelings about your bill, but this case actually, and we'll read from, I guess, page 559 of the Virginia Reporter. It says that the evidence must support a finding of intentional loss or destruction of the evidence in order to prevent its use in litigation before the court may permit a spoliation inference. So what I would wonder, and maybe those who are going to testify in opposition to this, is, I mean, does that mean that a jury can't even use the destruction of that evidence as circumstantial evidence to allow it to form an inference?
They certainly couldn't get the instruction what juries rely on, what juries rely on. Here's the problem with this case, and actually there's another issue in the case about experts that I didn't even try to address. The problem with this case is every lawyer in Virginia should now be advising every client pre-litigation to make sure all the evidence disappears. Because pre-litigation, you don't have the same burdens like what we've seen when Facebook stuff gets deleted after a case is pending. Because then the burden shifts to the requesting party to prove that that disappearance was out of bad faith. Because all of that evidence exists in the person that spoliated, I hate using that word as a verb, but the person that spoliated, you'll almost never be able to prove that. I've had one case in my career where we got a spoliation instruction where we actually found an email where the person said, we need to destroy this evidence so they can't find it in the case. That would have met the burden in this case. Otherwise, you're never going to be able to prove it. And one more thing about that case. This bill would not have mandated a spoliation instruction under those facts, and it wouldn't have mandated a spoliation finding. It would have given the judge the authority to make that decision.
What would happen, I'm just wondering, and maybe our counsel would comment on this, but what would happen in a criminal case if a defendant wasn't allowed to argue a inference on the basis of the loss of potentially relevant evidence? Steve, how would that affect your ability to defend somebody?
It'd be catastrophic, but nothing will constitutionally be able to prevent me from arguing an inference to be drawn from the facts proven at trial. If a defendant cannot argue to the jury an inference to be drawn from the facts at trial, including, well, that would be unconstitutional. That'd be a restraint of an ability to mount a defense.
Okay.
Here's where I think you run into a problem, because you're exactly right. But if you can't get the instruction, it may not be relevant to introduce as evidence at trial. And so the issue you may have is, if it can't go to the jury on the question, then the evidence is not relevant, therefore the evidence is not admissible, therefore you don't have anything to argue based on.
Mr. Chairman, I think that is not quite correct. Evidence is either admissible or not, irrespective of whether an instruction might be given. You only get an instruction if evidence is in the case that permits the instruction.
But
so it's
Steve, doesn't this case speak to whether an inference is allowed as opposed to whether a instruction is to be given, that passage I just read?
Let me take a look at that, if I may.
Mr. Chairman.
Senator Stewart.
While you all debate the issue of the inference, Delegate Habib, as I read this, an agent of a party could destroy something that, and do it for no other reason than it was time to purge it.
Yep.
Would have no indication of what may be relevant to litigation.
Correct.
Or that litigation was probable.
Yep.
And that's what really gives me pause in this. You
Sure.
say that you've drafted this
Yeah,
very
so let's
narrowly.
walk through that.
It's
Exactly.
incredibly broad. Now, it's one thing to say if a party destroys something where they know litigation is pending or probable and it will be relevant. And in your introduction to this, you said information that will be relevant. That's not what your bill says. It says maybe and probable, and you're extending this down the line to third parties.
Sure.
I mean, to me, you've brought every possible thing in here.
Yeah.
And it's just way too broad.
So let me walk you through that, because that's exactly, frankly, the rub on this. So if you look at line 16, so it only applies to parties, agents, or people acting at the party's control. So it's not totally unrelated third parties that may spoliate. They have to know or reasonably should know that it may be material to pending or probable litigation. So they have to know pending or probable litigation, and they have to know that it may or may not be.
That's my point.
Yep.
You're talking about agents. How are they supposed to know that something may be relevant or that litigation is probable? Now, pending is one thing.
Yeah, so that would be the defense to the question would be, we didn't know, we didn't reasonably know, and that would be one of many objections to the offering of a spoliation instruction, would be to say, well, we didn't reasonably know that litigation was probable or pending. You may not even know pending litigation. So that's one level at which you would object to the instruction.
Mr. Chairman.
Senator Stewart.
But you've put those people in a box because it's impossible for them to show that they didn't know it may be relevant or that litigation was probable when you're looking at it after the fact.
Yeah, so we ask judges all the time to decide the propriety of instructions based on facts. And so if I'm the party requesting a spoliation instruction, I would come in and say, here's the evidence, they possessed it, they should have known I was going to bring a claim or that I was going to use it as a defense. They destroyed that. I would like a jury instruction giving the jury the right to make an inference. The spoliating party would say, we didn't know litigation was coming, it wasn't unreasonable, and they would object to that. And like every other jury instruction, we would rely on the judges that the very smart people on this committee pick to make that determination.
And Greg, isn't there also a missing witness instruction that?
That's right. Very, very similar.
Yeah. All right. Let me ask you this. I mean, do you have concerns about whether this language that I read on page 559 could be used by a defendant or by a plaintiff to file a motion in limine to argue that evidence of the loss of a piece of evidence is not admissible, not relevant on the grounds that there's no evidence that it was intentionally done. And if it wasn't intentionally done, therefore, it's impermissible for a jury to form an inference on the basis of that, so it wouldn't be relevant for anything.
That's exactly what I was getting at with Mr. Benjamin, was if you can't get the instruction, then it's not relevant, therefore you can't argue the inference to the jury.
But this language goes farther than the instruction. It says no inference is permissible. I mean, not that an instruction is permissible, but no inference is permissible.
That's right. And look,
Right.
the goal
Senator
of this was not to change the law dramatically from
Peterson.
where we've all thought it always was.
Mr. Chair, I actually looked up Rule 37, and let me just tell you what Rule 37 has two different points, and obviously this deals with discovery in federal court. First of all, it is the duty to preserve electronically stored information. That's the caption in the rule, in the sub-rule. Then it talks about when it finds acted with intent to deprive a party, the other party, when one party acts with intent to deprive another party, there is a whole list of remedies. One is you can instruct the jury that it may or must presume.
That's right.
So actually, the federal rule can in some ways be stronger. I think Delegate Habib's bill, in my way, is a little bit more gives a judge a wide discretion.
Yep.
So it's, in some ways, the federal rule is probably more pro-defense, in some ways, more pro-plaintiff. But regardless, the Supreme Court, what we currently have is unacceptable. I think we can all agree on that.
Let me just tweak one thing you just said. It's not a plaintiff versus defendant issue.
That's a good point.
Oftentimes in products cases, the spoliating party is the plaintiff that has the product. It's the spoliating party versus non-spoliating party. What the U.S. rule, what the federal court rule does, there's two important words in there, must and presumption. They not only can say you may presume, they can say you have to presume that they did this in bad faith and spoliated. That's a much more oppressive rule. Now, the reason the knowing makes sense in 37 is because you have that mandatory obligation to preserve electronic evidence that doesn't exist in the state law.
Well, the federal rule also permits essentially a summary judgment.
That's right. That's what you're heading
pretty
towards.
draconian.
That's why you have those presumptions. It sets up summary judgment.
Any other questions
Yeah,
of patrons? Senator,
Mr. Chairman.
I'm sorry, Senator Sturdivant, then Senator Edwards.
Mr. Chairman, Delegate Habib, the question, the trouble I'm having is in a car crash case.
Yep.
If you take your car to get, a potential tortfeasor takes their car to get fixed at the mechanic and gets it fixed and then gets sued, will they not then are likely to get a spoliation instruction for simply getting your car fixed?
Yeah. So again, we rely on our judges to make these types of decisions every day with jury instructions. So the question the judge is going to ask themselves is that behavior such that I should instruct the jury that they may make an inference from that? That's why people send litigation hold letters very quickly when lawyers get engaged, because there's a belief that that changes the reasonable behavior of someone's response. But again, all this does, because it could be the tortfeasor that fixes their car, it could also be the plaintiff that fixes their car and then wants to come in and argue force of impact. And the defendant says, no, you can't do that because you fixed the car. So it applies both ways.
Senator Sturdivant.
Just a follow-up question in a product liability context. You could have a choice of law issue where somebody sues in Virginia for something that happened elsewhere with a different statute of limitations or a different statute of repose that's much longer than perhaps we have here in Virginia. If you have a potential defective product, is the manufacturer going to have to hold on to this thing until the statute of limitations or repose in every single state runs?
Yeah. Sorry. So the way this works in the real world, and y'all know this because y'all do this for a living, if you have a product and you think it might result in litigation, before you destroy it, you put people on notice. You tell them, hey, we'd like to put this truck back into service. We'd like to fix this equipment. We'd like to stop storing this thing and throw it away. The people who do it right simply put everybody on notice. And when you do that, no judge is going to come in later and say, darn you, now there's an inference that it has to have. But keep in mind, even if the judge does that, it just says the jury may infer. So the spoliating party will still come in and say, we're really sorry that happened. We didn't know we were going to get sued. We thought the statute of limitations had run. We sent them a letter putting them on notice. This is so minimal to say the judge may give an instruction that says you may infer.
Senator Edwards, I'm sorry, you finished, Senator Sturdivant? Senator Edwards?
I've litigated this on more than one occasion. And I've had situations where a medical record, for example, was destroyed. Or a medical record was altered and certain parts were whited out and the original wasn't available. Surprise, surprise. And the judge kept it out of evidence. Case settled pretty quickly. This doesn't say that the judge can keep something out of evidence.
Correct. It's not a rule of evidence, it's just an instruction. And so that's a perfect example. And the medical records world is largely different now because of electronic medical records, so you can track the audit trail when you see edits to records. But take it out of that and put it in the context of a regular business record that doesn't have the federal rules on maintaining records. There are all kinds of legitimate reasons why you modify or don't preserve records in business. And that would be the argument that the party maintaining the record would make. That, yeah, we write over this spreadsheet as more information comes in or whatever it might be. This doesn't require an instruction or presumption. That's why we didn't take the Rule 37 approach, because of the scenario you're
So,
outlining.
Mr. Chairman, so what my scenario of a judge keeping it out of evidence, this wouldn't affect that.
Yeah, so I think what would happen in your scenario is pre-trial, when you're dealing with proposed jury instructions or at a motion limiting stage, you would say, I would like to offer this evidence because I believe I'll be entitled to this jury instruction when the time comes. The judge is then going to have to make certain findings. They knew a reason we should have known that probable litigation, that they possessed it, that it was destroyed. And then the judge will make an evidentiary decision based on the likely jury instructions. Again, this is the stuff we ask judges to do every single day in every single court.
And under this, if a judge doesn't give the instruction, I mean, it would be reviewed on an abuse of discretion standard.
Reviewed like all other instructions.
I mean, it's not mandatory. The party would be able to argue that it's circumstantial evidence. I mean, it strikes me it would be pretty hard to.
So if the judge said, I'm not giving this instruction because you didn't prove bad faith, that'd be one thing. But if the judge said, I'm not giving this instruction because I don't believe that they knew or reasonably should have known that there was pending or probable litigation, that's never going to get reversed.
Or that they just got rid of emails because their standard 6-month policy.
That's right.
Yeah. All
Mr. Chairman.
Senator Peake.
Yes, Mr. Chairman, Delegate, the Supreme Court obviously came up with something and was basing their ruling on something. Where does the standard that they adopted in Emerald Point leave us with regards to the federal rule or with regards to the rule in other states, if you know?
I think I'm fine saying the Supreme Court bases all of its opinions on something. I do not believe in this case that something was anything to do with existing Virginia law. That is not existing Virginia law. So the federal rule, as Senator Peterson pointed out, is different because you have some mandatory preservation duties under the federal rules you don't have under state law. And so frankly, it's more burdensome in some ways and less burdensome in other ways under the federal rule. If you want to adopt the federal rule, which frankly I'd be okay with, if we adopted the mandatory preservation component of it, that'd be okay. I think other states are all over the place on the question.
Mr. Chairman, that was kind of my question. Is that rule inconsistent? And so you don't know?
I mean, there's states that have no such thing as spoliation. There are states that create a cause of action for spoliation, when you can actually sue for damages. Again, we're not doing that. We are simply trying to codify what all of us who do this for a living thought the law was before Emerald Point.
All right, any other questions? Let's hear from those who wish to speak in support of the bill.
Thank you, Mr. Chairman. I'm Lee Livingston. I'm president of the Virginia Trial Lawyers Association, and this issue has been ventilated very well by Senator Obenchain and Delegate Habib. Senator Peake, to answer your question about the majority of states, for those states that don't have an independent cause of action for spoliation, which is a much higher level of policing up people who would either lose or destroy relevant evidence that could turn the case against them, the majority of states follow the very sound Virginia rule that we've always had before Emerald Point. So this bill simply rolls back what happened 8 weeks ago. It simply turns back to what Virginia law had been for many years. Under the Wolf case, the Virginia Court of Appeals case, it was articulated really specifically. And what it does is it simply allows the court to ventilate whether a person who has lost or destroyed evidence should be held accountable to just a mere inference, allowing the finder of fact, allowing the jurors to say, hey, we hear that you've lost some evidence. And if you lost some evidence and you can't produce it and you knew it would have been relevant and it could turn the case against you, it's okay for us. We don't have to. In the jury instruction, I'm on the Virginia Model Jury Instructions Committee, we're careful. It says you don't have to conclude this, but you may conclude that if that evidence had been brought forward, it might go against the person who lost or destroyed it. But as Senator Overchain points out, by taking a shiny new principle out of the Federal Rule 37 and cutting and pasting it, but not cutting and pasting the whole thing, that is only directed at a small piece of electronically stored evidence and includes presumptions, not just inferences, they cut and paste a sentence or two, and they come up with a rule that is a big mistake, because what it does is provide a huge shield to anyone who would lose or destroy evidence, and it takes away the deterrent effect of a possible presumption by allowing people who are careless, who are negligent, who set up poor procedures to get away by excluding that evidence entirely. Senator Overchain is exactly correct that it would end up in a situation where you couldn't even talk about the fact that there's missing evidence, much less tell the jury you might consider the effect of the missing evidence. And that's why we urge you to support this bill. The checks and balances system works so well among our government. Not often does this body have to step in to address when the Supreme Court might have stepped over and gotten something a little off track. But occasionally it happens, and this body has done a great job fixing those things when they pop up. And we just think this would be an easy fix to go back to what the well-settled rule was in Virginia, because it was no problem. Nobody was knocking on your door to ask any questions about spoliation before Emerald Point, and there were not many appeals on it. It was working real well, and we'd like to see it go back instead of creating a situation where people can destroy evidence and the jurors might not hear anything about it or even be told about it, because you have to prove they intentionally did something they knew would jeopardize the case. The last point I would make is this would incentivize people when they get those spoliation letters, those hold evidence letters that Delegate Habib just mentioned. Under this rule, you can put that in a drawer, or you can establish terrible procedures. You can delegate it to the newest employee to address it. You can delegate it to somebody who's not qualified to do it. You can be careless, negligent, whatever you want to do, and then you can get away with that with impunity. Because you would have to prove they intentionally did something to destroy it before you'd ever get that evidence to see the light of day. So thank you for your attention. I'm happy to answer any questions.
All right. Thank you very much. Anybody else wish to speak in favor? How about in opposition? And that, I know that some of you have not been here in this committee. Good to see you, Mr. DeLuca. Welcome to the Courts Committee.
Thank you. First time for everything.
Since you have not been here, we run a timer, and I ran 5 minutes for pro, and we're going to run 5 minutes for con, and it's for everybody, not for each person. So go right ahead.
Mr. Chairman, members of the committee, Stephen DeLuca from Capital One, respectfully opposing this bill. I would like to turn it over to my colleague, Jason Eakes. He's Assistant General Counsel at Capital One, runs our discovery program. He also teaches discovery law at Richmond Law School. We believe he's well positioned to articulate the concerns of the business and the business community and answer your questions, so I don't have to.
Thank you.
Good morning, Chairman, members of the committee. Thank you for having me. Speaking today against House Bill 1336 because it conflicts with federal law in this area and imposes a significant burden on Capital One in terms of compliance.
And I'll stop.
Sure.
How's it conflict with federal law?
So as we've heard from Delegate Habib, Chairman, federal law requires a showing of an intent to deprive or a finding of intent to deprive by the court prior to allowing an adverse inference instruction.
No. You're referring to Federal Rule 37.
I'm sorry, I thought you asked about Federal Rule 37. My apologies.
Yeah, I mean, that is what, yes. Yeah. I mean, that's what you're referring to, right? Right?
I am, correct, yes.
But that deals with a presumption, not an inference.
It actually has both. So under Federal Rule 37, the court has the ability to either give the jury an adverse inference, either mandatory or permissible instruction. So the permissible instruction would be what you think of as the adverse inference that's currently in the bill before you. The mandatory presumption is, or mandatory inference is much more of a presumption. The jury is required to presume that the evidence that's lost would be unfavorable to the party who failed to produce it. That's not the language in this bill.
Mr. Chair.
Senator Peterson.
May I ask the gentleman a question? Sure. You realize that in the federal system, when you file a federal case, you get the initial scheduling order. There's actually an entire paragraph on preserving electronic records that we don't have in the state system at all. So the federal system has a whole different structure to it. You realize that?
Yes, Senator.
Okay.
Okay. Go right ahead.
So the real challenge for companies in this area is, for multi-state companies like Capital One, trying to identify and preserve information relevant to lawsuits is exponentially more difficult when there's a inconsistency in the laws that we have to design a compliance program around. The federal rules were amended in 2015 for many reasons, as you've talked about. But one of the balances it struck was whether or not you had to show an intent to deprive before allowing a jury to get an adverse inference instruction. Those instructions can very often turn the jury against the party. Judges are considered powerful people. When the jury is told something by a judge, they tend to give it a lot of credibility. What the federal rules did was to...
So, all right. Do you have, and I'm stopping the timer. I am going to let you talk, but so do you have Federal Rule 37 there?
I understand it, yes, sir.
You have it there? Show me where it talks about a inference of, where it talks about an inference.
So I don't have the language of the rule in front of me, but
I've got it.
Okay, it says that only if the court finds an intent to deprive, it should be the section B.
I'm looking.
Correct.
Only upon finding that the party acted with intent to deprive another party of the information's use in litigation may A, presume that the lost information was unfavorable to the party, B, instruct the jury that it may or must presume that the information was unfavorable. So A is, I believe that's for cases in which court is the decision maker, where it presumes that it was unfavorable. B is for jury cases where it says that it can instruct the jury that it may or must presume. And C is dismiss the action or enter a default judgment. I mean, it doesn't talk about inference anywhere. I mean, I would think you'd like this a lot better than Rule 37.
Well, the language is slightly different, but the adverse inference...
Well, the difference is not just slight. It's an inference versus a presumption. I mean, that's a big deal, isn't it?
Sure. In the minds of the jury, I would say, well, here, talking about the language of the section, though, may instruct the jury, it may presume. That is functionally the same, in my opinion, as an adverse inference, a permissible adverse inference. So in the current bill, it would allow the jury to presume. It could presume at its choice. That's no different than a permissible adverse inference under federal law. And with that, I'll...
Mr. Chairman, members of the committee, Matt Bruni with Virginia Bankers Association. We oppose the bill representing an industry that produces and stores a tremendous amount of documents that want to be used as evidence with specific regulatory requirements on document retention. We fear that simply following the guidelines that would lead to adverse jury instructions under this bill without that bad faith standard. Doing so could lead to more burdensome and expansive efforts to preserve documentation for especially our community banks. And as Justice Kuhn said in his opinion, to allow such a severe sanction as a matter of course when a party has only negligently destroyed evidence is neither just nor proportionate. We agree.
Thank you.
Thank you. My name is Richard Samet. I'm here on behalf of the Virginia Association.
And I'm going to cut you all a little slack, give you some extra time,
Okay.
So don't sweat it too much.
Thank you, Senator. What I wanted to point out, if you look at the bill itself, lines 13 and 14, there is an issue in there that makes it much broader than simply turning the clock back to before the Emerald case. Lines 13 and 14, the last couple of words read that the test for whether or not the document was material or the evidence was material or relevant or however you want to describe it was, and I quote, if the item is something that the other party may have desired to introduce at trial, that is a much different test than the existing test under the law before Emerald and after Emerald. The test prior to that was that, and I'm going to quote from Emerald, that the destruction of the evidence will interfere with a party's ability to establish some element of its claim. That is a different animal. You are not asking the court to just simply take the word that I wanted to put it into evidence. You are asking the court to actually take a look at it and say, yes, it's material, yes, it's relevant, and yes, it impacts this party's ability to put on their case, which means this is an entirely different animal than it's being described as. Furthermore, maybe I've misread it, but in line 18, there is a line, the word is that if they fail to preserve the evidence, failing to preserve the evidence would cover accidental destruction. It is way too broad. It needs to be tailored, narrowed down, and put in a different context than the way it is at this time. So we oppose it.
Thank you.
Mr. Chair, members of the committee, Brian Porter on behalf of the Virginia Association of Commonwealth Attorneys. I'm the Commonwealth Attorney for the City of Alexandria. We oppose the bill for a very simple reason, Mr. Chair, and that is by its terms, it does not specifically limit itself to civil proceedings. If the bill were to be amended to include a phrase in line 15 in any civil matter or civil proceeding, we would no longer object to the bill.
Okay.
Jeff Palmore with Reed Smith on behalf of the Virginia Chambers Institute for Legal and Regulatory Reform. We are also opposed to the bill. It's important to note in the Emerald Point case, the evidence in question was a furnace that the defendant kept at a storage unit for over a year and was disposed of well before the litigation was even started. It's important to think about what is the impact of this legislation going to have on the citizens of Virginia. If you've got a furnace like they did in the Emerald Point case, when can you dispose it? How long do you have to pay for a storage unit to keep it? Probably this full statute of limitations, maybe add a year for service. I think we need to think about the impact of this on the citizens of Virginia. The legislation would allow the court to instruct the jury that they may infer the evidence would have been detrimental to the case, even when there's no bad faith or intent to deprive the other side. We think this is the perfect kind of issue for a group like Boyd Graves to take on. Boyd Graves Conference is made up of plaintiffs' lawyers and defense lawyers. They can weigh these issues, evaluate all the complexities of the instructions in this case, and would encourage you to maybe look at a group like that to study it and bring it back for next year.
Thank you.
Thank you.
Morning, Mr. Chairman. Scott Johnson, General Counsel for the Medical Society of Virginia. With all due respect to our fine friend Delegate Habib, we oppose this bill. We consulted our litigators in our shop. Nobody's really talked about lines 22 through 24, getting away from the intentional standard or bad faith, and we're very concerned about that. We'd ask you not to go forward with the bill.
Good morning,
Yes,
Mr. Chairman, members of the committee. Tim Bentley with Norfolk Southern. I would just like to echo the comments made previously that we oppose the bill and would like to make two brief points. One, there's nothing in the bill that addresses any sort of proportionality of the extent of the inference made based on whatever the evidence is that may not be before the court, and nor does it address the issue of whether or not the evidence was available by other means or by additional discovery. Thank you.
Good morning, Mr. Chairman. Chris Legault for Nationwide Insurance, PCI, AIG, and Chubb. And for all the reasons previously stated, we oppose the bill. Thank you.
Thank you, Chris.
Mr. Chairman, members of the committee, Jackie Stone with Memorial Woods on behalf of State Farm. We join in opposition to this bill. Thank you.
Thank you. All right. Just Delegate, you want to close?
Yeah, a couple comments in response to things you've heard. I'm actually totally fine with what the VADA said in terms of tweaking when it kicks in, whether it's necessary to establish a claim, what a party might have been entitled to in discovery, what a party wanted to introduce at trial. There's lots of ways you could address that question on line 13 and 14. That their issue was that it said that they may desire to introduce at trial, and what they said was what they would rather say is relevant to establishing a claim or defense type of language. That's a totally legitimate way to go about the issue. I mean, that's a policy question of when it should kick in.
I think maybe Senator Peterson has a suggestion to address just that.
I have two potential amendments. One is on line 15. I guess I'll put them in a block. Line 15, I put if a party to a civil action, because I think it's fair to say we're talking about, I mean, Brady is a whole different animal.
You're going to get your counsel here excited about that one.
Okay, well, let me hold on. The other one I was going to say is on line 17 it says maybe material. I think we should make that is material. I think maybe is just too broad. I think is material is something there, it's gonna be a duty on someone. And let's face it, this has to do with emails where you have reason to know that that email is gonna be prejudicial to your side, and you dump it, and you delete it, and you get rid of that cell phone. Not to throw any certain quarterbacks under the bus, but we know who they
Yep.
are.
Yep.
Okay, that's something you know is relevant. So I would move the maybe to an is on line 17 and withhold the other at this point. I make that amendment.
I'm fine with.
Any second to that? It's been moved and seconded. Any discussion? Does that make it marginally better?
I mean, again, I think the language as is relies on the court.
It's just the amendment to line 17. All right. All in favor signify by saying aye. Aye. All opposed to that amendment? All right, well, let's put the vote up. Open the roll.
Got my back.
Ayes
right.
13, those two.
Okay.
Mr. Chairman, as to the civil question, I don't practice criminal law. I actually had civil cases in mind. Frankly, though, if the government who can take away your liberty is spoliating, I think the standard ought to be actually even higher for them than this. But I was not trying to get at criminal cases. But the idea of the government being able to take your liberty by destroying evidence and you have to prove bad faith as a defendant, if I'm a criminal lawyer, that would matter to me.
Mr. Chair, if I might, my only thing would be you have a whole developed case law along with Brady. So I'm not sure if how this would interplay with Brady.
I can tell you on the House side, the Commonwealth's attorneys asked us to put in an amendment that said in civil cases, I frankly thought they'd come here today and do the same thing. I'm ambivalent on the question.
Okay.
Well, I'll make the motion to just say in a civil action after if a person on line 15. I'll make the motion.
Is there a second? All right, it's been moved and seconded to make that amendment. Steve, you have any comment?
I think the patron is correct that what's at jeopardy in criminal cases is far greater than what's at jeopardy in civil cases. It's hard to get, for a defense lawyer, to get too concerned about claims involving mere money when our practice involves liberty or life. The problem with Brady has nothing to do with this. Brady, for those on the committee who don't know, Brady is a constitutional obligation of the prosecution to provide any information they have that is favorable to the defense. But if the police, for example, destroy something that may have been favorable to the defense, there is no remedy unless you can show that it was a destruction in bad faith, knowing that it was favorable to the defense. But that doesn't go to the jury. If the police destroy, say, a physical piece of evidence that could have been tested to determine guilt or innocence, then that should permit an inference by the jury that it would have been contrary to the state's interest. And the reason it's a good thing is it then would encourage better police practices to preserve evidence. Without the evidence that can be tested, without evidence that might be favorable to the defense, that's how you get wrong results. So if this is important and vital for civil claims, it is at least as important to criminal prosecutions involving liberty.
So I agree with everything Mr. Benjamin said, but again, I don't practice criminal law. I'll leave it up to you all who do.
Mr. Chairman,
Senator McDougall.
just regardless of what Senator Stanley says, this is a pretty big change in the criminal direction. And what I'm trying to get my head around is certainly if an officer's taken out a charge, a warrant, or gone for an indictment and then destroys evidence, I'm very comfortable with this being applicable. But what if there's an investigation that's ongoing for a period of years and there's something that's destroyed? Narcotics officers that are pursuing an investigation for 2 or 3 years and they destroy some of their text messages along the way, or now they're going to be in violation. So it's going to go back to my concern that if not been addressed by the amendment, and what is probable litigation, and how are we defining that? It seems pretty amorphous.
Mr. Chairman, that's a good point. I'll note that in Virginia Code, Section 55-510, there is a definition of pending or probable litigation. That definition would be probable litigation means those instances where there has been a specific threat of litigation from a party or the legal counsel of a party.
And we chose that language because of its definition elsewhere in the code. It's actually very, very narrow. I mean, even if you think there's going to be litigation, but you haven't been specifically made aware of it, you would argue that that's not probable litigation under Virginia law.
Mr. Chairman, I think Senator McDougal's point would be that this bill does not include a definition of probable litigation, and so if the patron wished, it could be amended to include that definition.
As defined by or including the same definition would be fine. Again, that language was chosen because it's defined in the code.
Well, why don't-
Mr. Chairman.
Hang on a second.
Yeah.
Senator. Oh,
Well,
Senator
we have,
Peterson.
well, I just say we have the pending motion, which I don't want to withdraw at this point, because I do think that we're talking civil cases, and it may be that this is a good idea to bring it back on criminal cases another year, but I think that at this point, I'd like to keep it just civil cases.
All right, is there a second to Senator Peterson's motion?
Second.
All right, it's been moved and seconded.
Mr. Chairman, speaking to it, I think council's right. If it applies to civil, it certainly ought to apply to criminal. And it has to do only with evidence which is material. And in the criminal context, the investigators are involved because of pending probable litigation or indictment or whatever. And it's particularly important in the criminal context that the investigators thoroughly investigate these cases and not just get rid of something just because, gee, maybe we're not going to be caught. So I think it definitely, civil should not be limited to civil.
Well,
And being somebody who's done both civil and criminal for many, many years.
Time out. Just in terms of how the code is constructed, Kristen, you have any thoughts as to how this would be applied given the construction of 801?
Well, Mr. Chairman, there are provisions in 8.01, especially in the rules of evidence, that certainly do apply to criminal cases. In this instance, though, we're talking about pending or probable litigation. So even if it is the intention of the committee that this does apply to criminal cases, I would think that the language would need to be tweaked more, because a court could read pending or probable litigation to just assume that we're talking about civil cases.
So as drafted, it's likely to be applied simply to civil cases.
Yeah, and again, that's what I was going at. I can tell you, the Commonwealth's attorneys came to me and said, Greg, you may not know this because you don't do criminal work, but a lot of times courts will read into civil rules of evidence into criminal cases. But it is drafted using the word litigation, and by putting it 8.01, the idea was civil to begin with, while understanding Mr. Benjamin's and others' concerns. Those weren't on the forefront of my mind.
Mr. Chairman.
All right, the motion is before us. Is this addressing the motion?
It is.
Okay, Senator Sturman.
I just want to, I think, echo Senator Edwards' comments that if we're going to apply this in the civil context where we're just talking about money damages, it is only fair that it also be applied in the criminal context where life and liberty are on the line. And so I would certainly oppose the motion that is on the table.
All right. All right, the motion is to amend to apply it simply to civil cases. Clerk will open the roll. Bryce?
This committee's fun.
Ayes 4, noes 11. All right, the amendment fails.
Yeah, so a couple other issues I wanted to
Mr. Chairman.
respond to.
Mr. Chair, I'm going to move that we add in that probable litigation means those instances where there has been a specific threat of litigation from a party or legal counsel of a party.
All right. Delegate Habib?
I prefer the language as is now. If it's the choice between getting the bill out or not getting it out, then I would view that as a friendly amendment.
We'll get
And
this into
I guess my only observation is that there may be cases in which a reasonable person would know that litigation is coming. Take the family in a car that's all killed. It takes a little while for them to be buried, to qualify executors, and tortfeasor may do something to destroy evidence in the meantime. So, you know, I guess no or reasonably no might be.
That's where we thought it was dealt with, because probable is broad, but know or reasonably should have known narrows it to things that a reasonable person would have anticipated. So that's why I like the existing language, but I understand.
You want to read your amendment?
Mr. Chairman, I just think it mirrors what's in the code as defining probable litigation in 55.510, and that it says probable litigation means those instances where there has been a specific threat of litigation from a party or the legal counsel of a party.
Right, and where are you adding that?
Mr. Chairman, it would
Kristen?
be adding a definition in subsection A where there's already a definition of evidence.
Okay.
What
Right,
Kristen said.
Is there a second to that? Senator Peak enthusiastically seconds that motion.
Yeah, again, I prefer the existing language, but.
All right.
Mr. Chair, oh, well, we got to vote on it.
We got to vote on this. Let's open the roll on that amendment.
Ayes 10, noes 5.
All right, that amendment's
Great.
adopted.
Thank you.
Mr. Chairman, before we leave that, if I may,
You may.
before we leave that question, the definition that has just been added, addressing Kristen's point that the use of the word litigation may be ambiguous as to whether it also applies to criminal. If it is the committee's wish that it apply to criminal, then after the word litigation, I would insert or prosecution, so that the definition of pending or probable litigation would be as follows. Probable litigation means those instances where there has been a specific threat of litigation or prosecution from a party or the legal counsel of a party.
All right.
Mr.
We'll see if there's a second to that.
No.
Or we'll see if there's a motion.
There's no motion.
Mr. Chair, oh, okay.
Hang on. Anybody want to accept Mr. Benjamin's invitation? All right, Senator Peak.
Mr. Chairman, I submit, I'm making a motion to PBI.
Well, can I, hang on, before you do that, I've got one further amendment to make before we do that.
Do we have another meeting?
No, yes, we've got other meetings.
This is too complicated to do it on the fly with these.
We're not doing it on the fly.
Yes, we
but
are.
I've got, Kristen, the amendment that I suggested, would you report that?
Mr. Chairman, your suggestion was on line 20 after jury may infer, insert subject to any explanation that may be made by such party.
No objection to that amendment.
Can you
All
repeat
right.
that? I didn't hear it.
One more time.
Line 20, after a jury may infer, insert subject to any explanation that may be made by such party.
So what this does is it waters down the inference marginally. So it instructs the jury to take into consideration the explanation that may be offered.
Well, Mr. Chairman,
I
counsel.
moved that amendment. Is there a second to that amendment? That amendment's been moved and seconded.
Speaking to the amendment, Mr. Chairman.
Okay, Senator Edwards.
Council's going to make whatever arguments they're going to make. I mean, that's implicit in litigation. You don't need this. It's totally unnecessary language.
Mr. Chairman, if I may, I totally agree, but I think if it brings clarity to people to make it clear that the parties are able to rebut the request, I certainly don't object to it.
Mr. Chairman.
So what this would address is if a company has a document destruction policy and says, yeah, it's gone, but it's gone because we purge emails after a month. So that motion has been made and seconded to make that amendment. Any further discussion on that amendment?
And I view that as friendly.
All in favor signify by saying aye.
Aye.
Aye. All opposed?
No.
All right, let's open the roll. All right.
Mr. Chairman,
Who's that? Senator Reeves.
the one non-attorney, or three non-attorneys on this thing. Mr. Chairman, I've been on this committee long enough to realize that this is, watching these two fight, that maybe this is something that might need to go to Boyd Graves.
No.
I just said, yes.
So to bring this to a close, Senator Peake recommends that this bill, you want to make your motion now?
I would say, Mr. Chairman, that we have another meeting, I'd move this to another meeting, pass it by for the week. With all these amendments and things that have been done, the Commonwealth's attorneys are opposed if it applies to criminal. I think it needs to be looked at.
It may not get back on the docket if it goes by.
And that was my question, if it does, okay.
So if you want to put a finer point on that.
Well, then I will,
Mr. Chairman?
then I will move to PBI.
Mr. Chairman, if I may, before you recognize the motion, if it makes folks more comfortable, I'm happy rejecting amendments on the House side and put it in the conference to give us more time to work on it, if that relieves concerns.
There's a motion to pass the bill by indefinitely. Senator Deeds.
Second.
To report as amended? All right, the substitute motion is before us to report as amended. Open the roll.
Ayes 6, noes 9.
Oh,
File everything in federal.
All right, the bill fails to report. The primary motion is to pass the bill by indefinitely. Clerk will open the roll.
That's my motion.
You want a substitute motion?
I will substitute the motion. Yeah, I would refer to Boyd Graves.
You want to carry it over for the?
Carry it over for the year, report it to Boyd Graves.
Carry it over for the year or carry it over for the week?
Mr. Chairman,
Right,
I will.
Motion is to
Mr.
carry the
Chairman,
bill.
I will make a substitute motion if we can carry it over for the week. I want to see these things. I want to get some input if we can do that, if we're going to meet next week. And then we can PBI.
We'll see. All right. Motion is that, is there an objection to carrying it over for the week? All right. The bill will go by for the week.
Thank you, sir.
We have two more quick bills. One, Delegate Toscano's House Bill 1249, which is the DNA bill. It is similar to Senate Bill 565. Is there a motion to conform and? I'm sorry. Let's conform it, but with trespass and assault and battery. Senator McDougal moves, Senator Stanley seconds. All in favor of reporting that bill is conformed with trespass and assault and battery signify by saying aye. Aye. All opposed? All right, that is conformed and reported. Also, we have delegate, all in favor signify by saying aye. Aye. All opposed? All right, also we have Delegate Kilgore's House Bill 669, which is a conveyance bill that simply allows the Commonwealth to accept certain property in Southwest Virginia. Is there a motion to report?
Mr. Chairman, there is a technical amendment on that needs to be made.
All right, Kristen?
On line 11, strike 10.1-109 and insert 10.1-114.
All right, Senator McDougal moves, Senator Stewart seconds that amendment. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment's made. Is there a motion to report and re-refer to finance? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right, open the roll.
Ayes 11, noes 4.
Oh, it's going to finance. Emmett or Tommy. All right. Does that complete the docket for today? Kristen, any others? Is that it? All right. The committee will rise.